Good morning all. We're here for a hearing in the matter of CFI 075-2018 before His Excellency Justice Ali Al-Madhani. Claimant is represented by Baker McKenzie, Habib Mulla. Lead counsel is Emily Albo.
Good morning.
I appear on behalf of the claimant today. Have you had a chance to read my skeleton argument?
I did, yes.
Perhaps the simplest way to proceed then. The matter is relatively straightforward, as you all have seen. The defendant, we believe, is acting in person but hasn't attended today. Perhaps I could address any questions that you may have first.
I can follow your order. You don't mind it. I think this would go fairly short, for a short time, I guess.
Great, Your Honour.
Yeah,
well, as you'll see,
do whatever you want. Any order you can take me, you can start wherever you want. I understand this is in Part 8 application. Okay, so you saying this is straightforward cases, should be dealt with on an expedited basis. You need the judgment just like the judgment, immediate judgment.
Yes.
But when it's come to the Part 8 claim, we didn't call it immediate judgment because it's meant to be, immediate one, I guess. So I understand that, but the only thing is this, during your litigation, I would like you to touch upon the jurisdiction. That's one. And then the defense that's submitted by the defendant. And I just would like to remind you your duty of full and frank disclosure. And if you can address me, what kind of any available defense would be any defense would be available for the defendant if there is any.
Great, Your Honour. If I could take you to jurisdiction first. So as you'll see from paragraph 10 of my skeleton argument,
right,
there are 2 points in respect to jurisdiction, procedural and substantive.
A and B.
Yeah. So in respect to the procedural position, Your Honour, the defendant failed to file a jurisdictional challenge within 14 days of filing an acknowledgement of service. And so if we then look at Rule 12.5, it states that if the defendant files an acknowledgement of service and does not make an application disputing the court's jurisdiction within this period specified, so the 14 days, he is to be treated as having accepted that the court has jurisdiction to try the claim.
Yeah.
That's the primary position. We say the defendant has accepted the jurisdiction of the court. The second position is even if you look at the agreement.
And you saying the defense that mentioning the jurisdiction is not a proper form of contesting the jurisdiction of this court?
Indeed. Although it was mentioned in the acknowledgement of service, they never filed a formal application, which they had to do. But if you look at the agreement between the parties, so particularly at page, apologies, sir.
The attachment to the witness statement?
Yes. Page 27.
Yes.
Clause 15, laws of jurisdiction. Clause 15.1, this facility letter shall be governed by and construed in accordance with the laws of the Dubai International Financial Centre. 15.2, any dispute arising out of or in connection with this facility letter, including any question regarding its existence, validity or termination, shall be subject to the exclusive jurisdiction of the courts of the DIFC.
I see.
My submission, Your Honour, this is a clear and unequivocal jurisdiction clause. My submission, the positional jurisdiction is simple and straightforward. The DIFC courts clearly have jurisdiction, and in any event, it hasn't been properly challenged by the defendant. As to their purported defence,
and the claimant is the claimant DFC entity, isn't it?
I think it's JAFs, if I'm not mistaken, Your Honour.
No, defendant JAFs, I guess.
Defendant JAFs, yes, we're DIFC.
You're a DFC.
Yes.
I see. So there are three things can be said about jurisdiction. So first of all, there is one DFC party, which may made it bring it under the gateways of Article 5(1)(a). The other thing, there is an obtained jurisdiction clause in the contract. The third thing, there is no contest from the for the contest of jurisdiction from the defendant, which seems to appear at certain time in this proceeding. Is that right?
Great, Your Honour.
Yes, go on.
Turning to their purported defence, again, there are two main submissions in this respect. The first is that, as the court well knows, defence provisions don't apply to Part 8 claims. And the defendant was informed of this by the court and was invited to provide evidence in reply to the claimant's submissions. And the defendant didn't do so. Even though it was expressly told by the court what it had to do, it didn't do it. So the primary position is they hadn't filed any evidence in response to the claim. So effectively, the claim goes unopposed. However, if you do wish to consider their purported defence, which we say that you shouldn't, but if you do, there is nothing in there that says that they're not liable for the sums owed. They try to challenge the validity of the agreement by saying that it's a document that originates from the Republic of Malta, which, to be completely frank, I'm not sure where they're going with that argument, and they're not here to tell us today. I mean, this brings it into the duty of full and frank disclosure that you brought up earlier, Your Honour.
Yep.
To be frank, I don't see that they have a defence of this claim. It's a very simple contractual agreement between two parties. The claimant lent them money. They failed to repay it pursuant to the terms of that contract. They're now liable for this debt. There's been correspondence with them. We have given them time. We have tried to engage with them. The reality is they just haven't paid. And I think that you can infer from their non-attendance today the fact that they don't have a defence of this claim. If they did, they'd probably be here and try and do something about it.
I see. Do you know what's stopped the defendant, coming to this court and defending this case properly, or even admitting this case and asking for any payment plan or something?
I don't know. What I can say is that they engaged with selecting the court's hearing date, so they are aware of the hearing today. And it was listed because today, I think they gave 2 dates, and today was one of those dates. So we're here today because they said that they could attend, and then they've chosen not to attend.
I see. Can you show me in the correspondence where they are engaged in selecting the date of this trial?
Yes, Your Honour. Apologies, if I could just have a minute.
Here, Charlie.
Have you got it on your laptop? Can you get it up? Your Honour, it's not in the bundle. It was an email from the registry, which I think we can get you a soft copy of. Can you?
Hannah, do you recall the defendant taking place and trying to decide the... do you have it? Why my screen now
Apologies,
working?
Your Honour.
Hannah, why my screen now working too? But if you have it, you can just read it to me loud, please.
Dear Sir, Madam, the defendant is not available for a hearing in January 2019. However, the defendant can confirm availability for the hearing in February 2019 as follows: 24th February to the 28th of February 2019, both dates inclusive. Best regards, Khalid Ahmed.
I see. And when this email sent?
9th of January 2019.
Okay. Sent by whom?
Khalid Ahmed from Farlin Group.
It's the same person who filed the defence on their behalf.
What is his position and his signature?
It does not say.
It didn't say. Is that Gmail or what?
It just says at farlindubai.com.
Oh, I see.
And if you look at page 38 of the bundle, that's the same name that appears as the person.
You said 38?
Yes.
Yes.
That's also, as you'll see, Khalid.Ahmed at farlindubai.com.
Yeah, he's the one filed the defense.
Yes. And again on page 40.
I see. Well, I noticed one defense is a bit lengthier than the other one. What's behind these two different defenses? Or?
There is nothing that I tell that is substantively different, save that the second adds in that I think it's effectively the way they phrased it.
Oh, I see.
I mean, effectively, again, they question jurisdiction, the validity of the documents, because they say that it's from Malta and that it's not valid in the UAE, and that we should bring our claim in Malta, not in the UAE.
No, I can see this. The second defense is like submitted 27th of December 18.
Yeah.
Well, the first one was like
So this is because
3 weeks before it.
Yeah. This is because if you look at page 58.
Yes.
So the defendant originally filed a defence, and the court wrote back, as you'll see on page 58, on the 13th of December, and said that the defendant had a period of 2 weeks to amend their submissions from a defence to provide evidence in reply to the claimant's submissions.
I see.
And instead of doing that, they refiled the defence.
Oh, I see. Yes, you may move on with your skeleton if you wish.
Okay, Farlin. That effectively concludes our submission.
That's obvious.
Yes. Very good.
Are you refer me to your skeleton argument and the particular of claim?
Yes. The particulars of claim are at page 6.
Yes. You're saying there is jurisdiction, there is no defense, no standing defense, and you want judgment. May I ask you how you calculate, as for now, the interest? Well, I remember, I think this is filed like 4 or 5 months ago,
Yeah.
the claim form. Do you have any update in regard of the interest calculation or something?
If I could just take
So,
instructions very briefly.
yes, please.
Your Honour, I'm told that it's the default interest as per the facility letter, but we haven't got a precise figure. We can calculate one for you if you would like us to do so.
Yeah, I would love that. I would love to hear what is the daily rate and on what basis as well. So I will see your calculation and will apply ours as well.
I'm afraid we can't get you a figure to date until Malta opens, I'm told.
I see. And when is that?
That's 2 hours from now.
I see. Do you have any draft order as well attached to this case?
No, but I can very easily draw one up for you, Rona.
Okay. That'd be good.
Do that now.
So I would love to receive a draft order from your side. Update us with the interest rate, daily rate, and the method of calculation and the base of calculation.
Great.
I think that's all for this morning. Thank you very much.
Thank you.
All rise.